earlier, as per Rule 96 sub Rule 10, exporter was not eligible for the option of export with payment of tax in case he was purchasing any supplies at concessional rate of tax. So what does that concessional rate of tax means? That either the exporter was purchasing by at the concessional rate of 0.1%, which is the merchant export rate, or he was availing the deemed export benefits, or under advance authorization. So in all these cases, when the concessional benefit was obtained by the exporter by way of not paying or the paying IGST on its purchase at a reduced rate, in all those cases, the exporter was not given the option to export on payment of IGST. So basically, what used to happen is, let's say I'm an exporter, I have purchased some goods for export at 0.1% by availing the benefit of notification number 40 by 17 central tax rate, if I remember correctly. So in that case, as an exporter, I purchased at 0.1% and I exported it on payment, and I paid 18% GST, including using some other ITC, because that 0.1% ITC is negligible amount. So I essentially use some other ITC of some other goods which I purchased, and then government used to give me refund. So government introduced this rule 96 sub rule 10 and rule 89 4B to say that in these kind of cases where the goods you are exporting, the ITC is either not present or very negligible. In this case, you cannot use some other ITC to make the payment on export to make the payment of GST using the option of export on payment and then claim the refund. So Rule 9610 was introduced, which said that refund will not be admissible in this case, of in case you are going for export with payment option. And Rule 89 4B was introduced to say that the exporter can only go for export without payment option, and in that case whatever that small portion of ITC is related to the export of goods, exporter will be able to get refund of that option. But practically it was causing a lot of problem in the industries, so these sub rules were omitted by the government on 8th October 2024. Now the issue which went to High Court is, in the case of Elstorm, they had some pending application, refund application, which they had already filed, which was pending as on 8th October 2024. Then this rule was omitted. So the assessee went to High Court, and High Court held that since this rule was omitted straight away, there was no saving clause. Then, as per the general understanding of the law and as per the provisions of General Clauses Act, if any rule is omitted without any saving clause, then that rule is basically considered erased for all intent and purposes and from starting of the time. So all the transactions which have happened prior to the omission of the rules, those transactions will not be disturbed. So any refund claim which has been filed prior to the 8th October 2024, which has been granted before that period, and there is no litigation going on. So those orders are not in challenge, they are not in appeal. All those refund orders, they have attained finality. Till 8th October 2024, they will not be impacted by omission of these two sub rules, but any application, so either application is made after 8th October 2024, a period is after 8th October 24, that is very clear, or the period is before October 24, refund application was also filed prior to October 24, but either the refund application is pending or refund was granted or some partial portion was rejected, and the assessee, all the department, they have gone into appeal against the order which has been passed. So in all these cases, because there is some pendency as on 8th October 2024, so for all these proceedings, Rule 96 sub Rule 10 and 89 4B, both of these rules will be considered to be omitted, and the refund applications, these proceedings have to be concluded, assuming that Rule 9610 and 89 4B were never part of the law book. So we have had some earlier judgment also on this very principle. If I remember correctly, that was also given by Gujarat High Court only. So, but since this was an important issue, so we thought that we'll cover this same issue, new judgment. So we thought we will cover it again. So over to you, Ayush, if you have any comments on this.
Correct. Yes, I think this is not a new judgment, obviously, because I specifically remember when we were working on one client. So they do not have a system to segregate their goods, that what are the goods being imported and then when they will be exported without payment of tax or with payment of tax, what are the raw materials being used. So everything was required to be maintained separately. All the records were required to be maintained separately, even when the same goods that are being exported may be exported under 9610, that or may be exported without payment of tax or with payment of tax. So this distinction or this segregation was causing a lot of problem. That is why it was necessary to remove these clauses from the GST Act. And now the judgment has been rightly said that since there is no saving clause in that, it should be applicable retrospectively, and whatever the refund applications are pending should not be affected by this. I mean, should be done as per the retrospect, as per considering this as a retrospective amendment only. Uh, okay. There is one query in the chat box that we can take later, I think. Uh, okay, one judgment in the case of Kuhen Nagel Private Limited, Gujarat High Court. So what happened in this case was that the refund application was filed by the appellant and that got subsequently rejected. The appellant went on till the High Court to fight the case, and the High Court allowed the refund of the assessee of the appellant. On the basis of that High Court judgment, the appellant filed a fresh application for refund, and that refund was subsequently granted because the High Court allowed so. The issue arose is related to the issue that arose in this case related to interest. That from what date the interest is payable in the present case. Is interest payable from the date when the original application was made and that got subsequently rejected by various authorities, or the interest is payable from the date when the new refund application subsequent to the order of the judgment of the High Court was made? Because there is a provision under the GST law that that refund has to be given within 60 days from the date of refund application. Then only the if it is not given within 60 days, then only at section interest under section 56 is payable. So if I count 60 days from the new refund application that was filed subsequent to the order of the High Court, then that refund was given within 60 days and no interest was payable on that. However, when I calculate the period from the original refund application, the interest amount came to be very substantial. So in this case also, in this case, what the Gujarat High Court has, rightly held that the interest period of the refund application, original refund application should be considered for the calculation of the interest period, because the assessee was entitled to the refund as and when you filed the original refund application. However, due to the certain disputes, as the department did not agree to whatever the refund was filed, the refund was not granted to the assessee. Again, this ratio has been a long-standing ratio by various high courts, even the Supreme Courts. I specifically remember there are various tribunal judgments as well in the service tax era, central excise era, pre-GST era, that refund should interest on refund should always be given from the date when the from the original application date and not from any other subsequent application or refund application if that has been filed pursuant to any order of the High Court or any other court. So this was the judgment. Mohit, you would like to say anything?
I think it is more or less a settled issue.
Yes.
And sure.
Okay. Uh, Another judgment that I would like to discuss is Kanakia Spaces Realty Private Limited, Maharashtra, Bombay High Court. Again, a settled ratio, but important to discuss because what I have seen or what we have seen in many of the cases, department is not adhering to section 87. So what section 87 says is that whenever the entities get merged, any proceedings thereto or any notice thereto shall be served on the new entity or the resulting entity. So in the present case, what has happened was that Again, two companies got merged, but the show cause notice, post-merger, the show cause notice was served for the period when the old entity was in existence, but the show cause notice was served after the merger, and it was served in the name of the transferor entity or the old entity only. And many a times we have seen over here as well, in many cases, that even when it has been specifically communicated to the department, ITC 02 has been filed and every NCLT order has been given and everything has been clearly communicated to the department, then also the order is served on the old entity. Maybe there is some differences on their portal. They are not able to give maybe they give the notice to the new entity on the new portal. But whatever it is, Section 87 is clear in that regard. And Bombay High Court again in this case uh, said that whatever the notice was served was incorrect, as it has been submitted, as that it has been served to the wrong entity, which was not in existence at the time of the serving of the show cause notice. Therefore, this is the show cause notice on is not valid and it should be served on the new entity only. Again, a settled principle, but important to discuss, as practically we in itself are facing many cases like that. Would you like to discuss something on next case law?
Yes. So next case law we have just a second. So next we have by Assam High Court in case of Devabrata Bhomik versus Union of India. So in this case, what happened is assessee got an order from the department. Assessee first went for rectification of that order. However, the rectification application was rejected by the department. Thereafter, the assessee went to file appeal against the original order, which was passed by the department. By that time, the time limit of 3 plus 1 month from date of the original order, that time limit has lapsed. However, that was within the time limit from the rectification order. So in this case, what the Honorable High Court held that whenever the assessee had gone for an alternate remedy of rectification application and that gets rejected, and subsequently the assessee wants to file appeal against the original order, so the time spent in pursuing that remedy of rectification application, that should be excluded from computing the period of limitation. So what does that mean? So let's say today we are on 11th July. I receive a order. On 11th August, I file the rectification application. And on 11th October, the rectification order is rejected. So the time spent in pursuing rectification application is 11th August to 11th October. That is 2 months. So these 2 months should be excluded while computing the time limitation of 3 months plus 1 month. So if these 2 months is excluded, then the revised timeline will be originally the date would have been from 11th July, 3 months would have gotten completed on 11th October. But since those 2 months have to be included, so sorry, 2 months have to be excluded. So effectively, we can add those 2 months. So 11th October plus 2 months, 11th December. So the revised timeline would be 11th December for the normal limitation plus 1 month for the condonation period. So within that time limit, if the assessee is filing the appeal, then the application will be treated as valid application, and that should be considered by the authorities as being within filed within time. That should not be rejected on time barred ground. However, one very important point we have to notice, sometimes what assessee thinks or the consultants also think is that if a rejection order has been passed by the department, then they get a fresh time limit of 3 months from the date of rectification rejection order. That is only true if you want to file appeal against the rectification rejection order. But if you want to file appeal against the original order which was passed by the department, in that case, if there is a time lapse between date of the original order and filing of the rectification application, that time limit also has to be considered. So that is one very important point, because that is one area where a lot of assessors make mistakes, and later on that caused them in tribunal or high court when that high court holds that it will still be time barred. So I think Ashok Jha ji has sent some message. So Ashok ji, whatever query you have, that we can take up after we finish discussing the case laws. Akshat ji has also sent a query. What if appellant has filed appeal on precaution basis as a rectification application is pending to keep its appeal right intact within 3 plus 1 month from the date of order and rectification application is rejected subsequently. So, Akshat ji, on face of it, this practice is not legal because you should go for one remedy only. Parallelly, SSC cannot go for rectification as well as appeal remedy. In this case, however, since you filed both appeal as well as rectification, and rectification application has been rejected, then you can continue your appeal process. Although in future, I would recommend that SSC should refrain from pursuing both the remedies parallelly because that can create a lot of problems. So that can, in that case, what happens is even if let's say you got a favorable order in rectification, department can contest in future that that rectification request was itself invalid because parallelly appeal was already filed. So that kind of issues can come if you are parallelly pursuing both the remedies. So I hope that answers your question. The
We can move forward.
हाँ
We'll Okay, so another judgment that I would like to discuss is of Kerala High Court. In the case of Messrs. PR Productions, interesting issue in this case is we all, again, a practical issue that we all are facing is whether recovery proceedings under Section 79 can be directly initiated by the department if there are any differences between GSTR 1 and GSTR 3B or between the returns filed by the assessee. So in this case, what happened was that there was a difference in the GSTR 1 return filed and another return. There was a difference again in the returns filed by the assessee for the period 21-22. The first plea that was taken by the assessee in this case was that the explanation that has been inserted with regard to self-assessed tax liability under Section 7512 was after the given period, I think somewhere in 2022. So that should not be applicable for the period 21-22. In this, the High Court said that the explanation whether or what is the meaning of self versus tax liability was also clear before the explanation was inserted. Therefore, they did not. High Court did not comment on anything whether it should be available retrospectively, applicable retrospectively or prospectively. The department in this case initiated the garnishee proceedings under Section 79 and initiated in the 79 and issued a notice for the recovery of the demand of around 44 lakhs. So there was one rule that was also introduced, Rule 88C, in which it was clearly said that whenever there is a difference between the GST or 1 and 3B filed by the appellant, well, filed by the assessee, then the department first has to issue DRC 1B and ask for the reasons for the reasons for such differences. The assessee has the option to either pay such differences in Part B of 1B or to reply. Then the department again has the option, if the reply is not satisfactory and all, then they can start the recovery proceedings under Section 79 as is written under Rule 88C. Section 7512 also gives the power to the department to initiate the recovery proceedings directly. But again, there was one circular or instructions that I specifically remember that in which it was instructed to the department that whenever such differences are there under Section 70, such differences are there, then instead of directly initiating the recovery proceedings, a notice should be given to the assessee. A notice can be in any form, may not be a show cause notice, a general notice asking for the information and to give the assessee the opportunity to explain such differences as to why such differences arise. And if the department is not satisfied with the explanation, then again they can start the recovery proceedings under Section 79. In this case, no notice was given to the assessee, no DRC 1B was issued. Directly, the garnishee proceedings under Section 79 was initiated. So, as held by the Kerala High Court in this case, that the recovery proceedings that are initiated by the department are bad in law, as there was no opportunity given to the assessee in accordance with the law. The Kerala High Court said that DRC 1B should have been issued first, and then only the recovery proceedings can be initiated in this case. But what my view is that even if 1B was not issued, any other notice that if the department is issued any other notice in any other form, that would also suffice the requirement of section 7512. And after the reply of that notice, if the department is not satisfied, then they can start the recovery proceedings. But one opportunity, either in the form of issuing DRC 1B or any other notice, should be given to the assessee to explain that why such differences arise in its self-tax liability, and then only such recovery proceedings can be initiated.
I think one other aspect which we should see when we talk about section 75 subsection 12. So even though they have mentioned that any difference, the tax which is shown in GSTR 1 will be self-assessed tax, and any difference in 1 and 3B essentially directly recovery proceedings can be initiated. But if we see section 7 defines supply. Section 9 then talks about levy on supply. So if I take a case where the assessee has shown some transaction in its GSTR 1, which is actually not a supply. Let's say the invoice was incorrectly issued, or even maybe the invoice was not issued, some incorrect reporting was made in GSTR 1. So in that case, section 7 never got attracted. Section 9, which is the levy section, that section never got attracted. So in these type of cases, whether the department can straight away go to section 75 subsection 12 and say, since there is a difference in GSTR 1 and 3B, and one is a self-assessed tax liability, I will straight away start a recovery proceeding. So in my view, even that determination still needs to be done. Because even though law has said that any amount paid in GST 1 is a self-assessed liability, but still the department has to give an opportunity to the assessee to prove that this is not actually a supply, or the tax is actually not payable. Because section 7512 cannot create an independent tax liability which is not envisaged in section 9 or section 7. So in my view, that proceedings in itself will be considered void ab initio in case opportunity is not given to the assessee. And in my view, proper show cause notice should be issued, not just a mere notice. Because otherwise, the assessee can always argue and say that this transaction itself was not, uh, uh, this transaction itself did not qualify as a supply. So section 9 did not come into picture, and therefore the section 7512 become infructuous. That section 7512 cannot apply unless and until there is a levy first. In case of short payment of taxes, for ITC, obviously, we had to go accordingly.
Correct. I think.
So I think that concludes our judgment portion. There are no other updates in the last week, any major updates. So maybe we can proceed to the query session.
Yes, sir.
One first query we have from Mr. Ashok Jha, a GST on sale of used cars. So, Ashok ji, sale of used cars. So the provisions have not changed since 2018. So we have rule 32 sub rule 5, which is for the dealers of second used goods. So for dealers of used cars, they from starting they have the option of paying on margin. And for all the taxpayers other than dealers, we have notification 8 by 18, which says you can pay on margin. What do you mean by margin? Sale price minus difference. If the sale value is less than the WDV, as per Income Tax Act, then you don't need to pay anything. So that note, and provided you have not availed the ITC under GST or VAT input under pre-GST regime. So provided subject to those conditions, you can pay on the margin 18% GST. Cess is not payable. So that is there from 2018. No change in that.
I think only rate has been changed because earlier there was some 12% rate on some cars. So that has been made to 18% or something has been
Maybe
done.
yes.
Otherwise, in conceptual, there is no change, whatever the Mohit has explained. Only rate has changed. Sorry, so you're not audible. I think Zamir sir, you're trying to speak or not audible?
Sameer ji and Rama Mohan, two people
Rama,
have their mic on unmute.
yes.
Rama Mohan ji is muted now.
मैंने वो उनका बहुत देर से unmute.
So, Sameer ji, are you trying to say anything or can we mute you?
We have one query in I have a query regarding the realization of export. So, Akshat, you are asking about this realization of export proceeds, particularly in relation to export of goods, that whether the export proceeds are compulsorily required to be realized. See, what is the distinction between export of services and export of goods is that if you are not receiving the foreign exchange at all, then this will, in case of export of services, then that will not be considered as export of services. However, in case of export of goods, there is no such there is no such condition made. But when I particularly talk about whether this forex is required to be realized or not, there is a one particular rule. I don't remember at 96B or 96 something. I'll just search and
96B.
96B. There is rule which specifically says that I'll read it for the benefit of all. Just a second, let me. 96B is the rule as far as I remember. 96B, है ना?
96.
Yes. So the rule says that where any refund of unutilized input tax credit on account of export of goods or of integrated tax paid on export of goods has been paid to an applicant, but the sale proceed in respect of such exports has not been realized in full or in part within the time limit allowed under FEMA, including any extension of such period, the person to whom the refund has been made shall deposit the amount so refunded to the extent of non-realization of sale proceeds along with interest within 30 days, or failing which the refund amount shall be recovered under section 73, 74 or 74A. Further, the extension is that in respect of are not realized, but the Reserve Bank writes off, then obviously you are not required to realize those sale proceeds. Now the subclause 2, clause 2 of what 96B says, where the sale proceeds are realized by the applicant in full or part after the refund amount has been recovered under sub rule 1 and the applicant produces evidence about such realization within a period of 3 months from the date of realization of sale proceeds. Amount so recovered shall be refunded by the proper officer to the applicant extend to the extent of realization of sale proceeds, provided these sales proceeds have been realized within such extended period as permitted. So I think Akshatji, whatever your query is has been answered, clearly written under 96B. Answer to that, I'll just brief you. So whatever the period is allowed under the Foreign Exchange Management Act, or whatever the extended period as you may take the liberty from the RBI, you are required to realize the sale proceeds within such extended period. If such sale proceeds are not realized within such extended period, then you are required then you are required to refund the amount. But what your second query is that if the export proceeds are not realized within the prescribed period, would the exporter be required if the refund already received, if such refund is reversed, can it be reclaimed when the export proceeds are subsequently realized? For that, we need to read sub rule 2, which says that if the export proceeds are realized later, then you will be granted the refund provided that these sale proceeds have been realized within such extended period as permitted by Reserve Bank of India. So again, even if you have realized your sale proceeds, what this rule clearly says is that that should have been realized in the extended period. So what happens practically is whenever you realize this foreign exchange, even after the period has expired, you can go and take a permission from RBI, get this verified that you can get your period extended, and this can be very well covered under the extended period by the RBI, even if it is realized after the period under FEMA has expired. So what we need to read from Rule 96B2 is that this should have been realized within the time period, whatever has been prescribed, plus the extension that whatever has been granted by RBI. Now, what is the prescribed time limit for realization of export proceeds? I think that is 1 year from the date of LEO. As far as I remember, I'm not sure on it, so I will not comment. Mohit, you have any?
RBI guidelines, I think that is some 9 months
9 months. Okay, 9 months from the date of LEO.
plus then I think some 6 months extension can be sought. So in general, but it is
Hmm.
9 months as far as I remember. It was
Hmm.
extended during COVID time, but I think now it
No,
is
again
again
nine
back to
months.
nine
Correct,
months.
correct, correct. Shweta ji has said that request to take session on 57th GST Council meeting. Sure, Shweta ji. Next half an hour we will allocate to 57th Council meeting in the next session.
And that also depends on how many decisions are going to be there by the council meeting this
Correct.
time. So if no such permission is follow-up question by Akshat ji.
Hmm.
If no such permission is taken, then it can't be reclaimed, even if proceed is realized in full and forex is received.
Again, procedural versus substantive condition.
So I think we have some judgments of high courts in case of services because in services you have a time limit of 1 year as per Rule 96A. So in those cases we have some two three judgment of high court wherein in GST as well as some judgments in service tax I believe wherein courts and tribunals have held that if the substantive condition has been satisfied of the realization of payment then merely because of delay in realization the assessor should not be denied refund. So, basis those judgments, we can argue and get the refund. Because this
Correct.
permission is also, if you see the RBI circular, permission, they have some automatic cases and automatic limits within which you can get the automatic approval. But if you want to get a specific approval from RBI or AD Bank, that becomes a very hectic task. So all the assessees may not have the required criteria and required influence to get the extent permission from the RBI. But if subsequently you're realizing, you should be able to get the benefit.
Correct. So, any other query that we have? Ramesh, if you're trying to speak, you can write a query in the chat box because we were not able to hear you.
Most welcome, Akshatli.
I think there are no. Hmm.
Good afternoon, Ayushji. See Govinda here.
Yes.
Sir, I filed the appeal last month. I want to give extra document related to appeal, but I'm not attached at that time while filing the appeal.
So, you're talking about tribunal?
Are you hear me?
Yes, yes, I can hear you. Am I audible to you?
Yes, 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 yes.
So, you're talking about appeal filed at tribunal?
No, no. First appeal.
See, when I say about specifically about tribunal, there are rules that no additional documents or grounds can be submitted without the discretion of the tribunal, and there is an additional cost to it. But when there is a first appeal, I mean, we always take a plea that we will submit the additional grounds or additional documents if those documents were what are those documents? Have they been produced? Have they been gathered later, although they were just missed out? Inadvertently.
At the time when we file the appeal, we have only 4 documents required to upload it. In one document is 5 MB.
No, correct, sir. But did you submit all those documents then physically to the department, to the appellate authority? See, if that is the case, because you were not able to upload the documents because of the size limits of the portal, you can obviously give a full set of all the additional documents as well as the old documents that have been uploaded. You can prepare a full set and submit it to the appellate authority. They will very well entertain it, provided that you have taken the references of those documents in your appeal. Whatever the statement of facts and grounds of appeal you have submitted, you have relied upon them and you have taken the references of those documents. But because there was a size limit on the portal, you were not able to upload those documents on the portal.
Okay. When I require to deposit all the documents there, full set, because I don't know which officer get this appeal.
Correct. Sir, APL 02 is been issued?
Not till date, not issue.
That is also not the case, because which officer will get the case depends upon what your jurisdiction is. So every, whether appeal 1, appeal 2, appeal 3, how many appeals, whatever the jurisdiction you are filing, it is clearly defined that even if there are 4 appeals, so whatever the jurisdiction at the lower level is, which ward or which range, which will go to which appeal. So there should be some internal circular over there, or you can go to the department and can get to know that which appeal will hear your case. Or even not so, you can just prepare a set, write commissioner appeals, and can go to the department and submit that copy in the dark. They will give it to the relevant authority over there.
Okay. Thank you. And if I can produce after APL 02, then any issue?
It is advised that you submit those documents as soon as possible, sir. Because they may also, if they read your appeal and the documents on the basis of this before issuing APL 02, they may mark some defect on it.
Okay, sir.
Although this is not practically I have seen anywhere, but it is advised to issue as soon as possible, to submit as soon as possible. Sorry. Yes.
Okay.
Now, you were saying something, Mohit?
Yeah, I was just asking if any other queries are there of any other participant. I think there are no other queries, so we can conclude the session.
All right.
Thank you everyone for attending the session, and hope to see you next Saturday.
Thank you so much, everyone. Bye.
Thank you.